Hello, everybody. Daniel Gaines here. Just figured I'd hop on and give an update since it's been a while. People probably wondering what the hell's going on. Uh, so here's how everything stands. I'll go through them real quick, case by case. The protective order is set with it finally been assigned a new judge 2 months later, and it is set for the 30th of this month, January. And then we'll see what happens from there. If the judge refuses to address the fraud, then a lawsuit will be filed. The judge will be informed right then and there that the lawsuit's going to be filed because their willingness to further the fraud makes them guilty of fraud. Let's see. So that's that one. The trespass case, well, that was sent over to the circuit court. Stuckmeyer's off the case. It's no longer in the municipal court, and that's because I filed a lawsuit against Stuckmeyer, Dugan, Emmons, their supervisor, and the court administrator, Miley, and that is pending still before the federal court. They filed their motions to dismiss. I filed my response, so it's just a matter of waiting on the courts to decide. If the courts grant the dismissal in my motion to reconsider, I'll actually literally spell out the fatal flaw in the prosecution's case. And that's almost going to force them to reconsider, because the appellate courts, the federal appellate courts, are going to have to answer the question if fraud can be the basis for criminal action against private citizens. And once they see the fatal flaw based on this circuit that I'm in Missouri, their own case law, well, everything leans towards my favor. I haven't spelled it out yet because I'm hoping I can first use it before the jury, because once I do it, it's going to become extremely evident and extremely clear just how quickly I'm going to make a mockery and an embarrassment of the entire judicial process. Because the fraud is that clear. 2 questions is all it's going to take me to do that in. And the second one's just a follow-up, not needed necessarily. The first one is one question is all that's actually technically needed, but the second one's just to rub salt in the wound and then grind it in a bit deeper. So I'm hoping I don't have to actually spell it out yet, because thus far all these idiots have refused to. I don't know if it's ignorance or just willingness to go along, to get along for all of these people, but thus far ain't none of them spotted it, or they just think I'm too stupid to see it. They should have known better. But anyway, yeah, so that's where that stands. I don't think it should be too much longer before the federal courts actually respond. I don't know for sure, but it shouldn't be too much longer before I know something, and then I'll either, like I said, file the motion to reconsider, or it'll progress past motion to dismiss, of course, unless they appeal that. And again, the case law is in my favor on that, so we'll see how it goes. But I will be showing their motions to dismiss and my responses, and from my point of view, their attorneys get embarrassed. Michelle Stallings is the main one, and she gets, I embarrass her only on the fact that she can't really cite anything except, well, they're immune. They should be allowed to do these things because they're immune. It's part of their job. Well, they should be allowed to do their job and have protection. Yes, I agree. But when they engage in fraud, that's not part of their job. They're prohibited, which means they have to step outside of their job to do that, and that's outside the law means illegal and illicit. They cannot be immune from that. And, well, I cite a fair bit of case law they just cite immunity. And obviously case law related to that. 12B, trying to get it thrown out, case law related to that. I get around that as well. But it's still, we'll see what the federal courts do. Like I said, I'll point out the fatal flaw, literally spell it out for them if it comes to that. I'm just hoping I can keep that concealed from everybody's knowledge, that I'm aware and exactly to what extent, until it gets before the jury. Now, the actual trespass case itself. That was in Division 12 at the Circuit Court. I believe it's Division 12 anyway. And Judge Antonio Tony Manansala's courtroom. Well, at the first hearing, he decided to violate my rights, engage in threats and intimidation. He violated his code of conduct and judicial canons. And he failed to address the fraud that's clearly in the court, on the court record and in numerous different court filings. Whenever a judge actually does have an obligation and a duty to look at the documents and everything in a case, whenever they get assigned a case, if there's any of those type of things, they're supposed to read motions and everything else. And since there's a lot of outstanding motions still in this matter that's yet to be addressed, there's no excuse for him not to have read through these things, to have seen my allegations of fraud. His refusal to do so resulted in him furthering the fraud, becoming part of it. As such, I filed a lawsuit against him. However, unfortunately, due to the weather, I wasn't able to get it filed until the morning of the 9th, which was also the morning of the last court date. The morning of the 9th, I went to the clerk's office first, but due to the amount of time it takes the clerk's office to file and process and file a lawsuit, because they got to get the summons and everything ready and all that jazz, combined with the fact that it's my belief that one of the clerks phoned Manansala and informed him, because I told him I had to be in court at 9 o'clock and was hoping it could get done before then. But I think they phoned him and let him know. Either way, the hearing at 9 o'clock was 10 or so minutes delayed, something like that. But because the judge was still in his office, either way, that morning I also filed a motion to recuse and a memorandum in support of motion to recuse, to have him recuse himself. In it, it stated I called him out because one of the things he did is he kept conflating state law with court rules and was ignorant of the difference between the two. Even whenever I pointed out that it's the law that says what he was claiming, he still insisted it was a state rule set forth by the Missouri Supreme Court. So he's ignorant of the difference between rules and laws. That was included in the memo in support of his recusal. But the most important aspect was what was at the very bottom. And that stated that either at the time of this hearing, a lawsuit would have already been filed, or due to the weather, it would have been filed that morning prior to the hearing. Well, Manansala at the hearing started off by admitting on the record he read my motion and my memo in support of, and then stated that upon reading them, he decided to retaliate and order a mental health eval. Now, I laugh at the idea because it's not needed for me to tell them what my issue is. However, the issue with it is he did it in response to a motion I filed, so that's retaliation. He did it absent any cause because, well, me calling out his misconduct is not sufficient legal ground for him to order me to go through a mental health eval. Further, he did it absent any legal reason. He couldn't cite or didn't cite a single thing to justify it. And those evals are a Fourth Amendment issue, right? They're invasive and intrusive. You don't have a choice or you go to jail. So it's a Fourth Amendment issue. Well, in order to strip someone of their rights, state governments and federal government can do so. However, there is a very high burden they must meet in order to do so. And in this, Manin Sala was just fucking butthurt because I called him out, and he couldn't handle it. His fucking fragile little ego couldn't handle being called out, so he retaliated. The funny part is during all that, upstairs at the clerk's office, they were processing the lawsuit against him. I literally walked out of his courtroom, went up to the clerk's office, paid for the lawsuit, had the summons for him right then and there. So he did all this knowing a lawsuit was being processed as he was doing it. So because he claimed to have read my document, he already was disqualified. He denied the recusal, but he doesn't have a choice. So yeah, it's likely going to be... Oh, the state Supreme Court's going to find out about this because there's going to be a habeas corpus and a writ of mandamus filed into this because of him and his actions, the retaliation. And yeah, we'll see. We'll see if I can't be the sole reason that Manin Sala's career is over early. Because I won't stand for it. It's also something that the FBI and DOJ are going to be made aware of after the inauguration. Once Trump's appointees are sworn in, that's whenever it's all going to go to them. Once they start affecting some change, because one of the things they want is accountability in the judiciary. So it's all going to go to them. However, the reason I pointed out a couple times that the lawsuit was being processed is the same day the lawsuit was filed, he gave me grounds to amend it into something 1,000 times fucking stronger due to the retaliation. So I've got the amended petition ready to go. Once Manin Sala gets served, the amended petition will be filed shortly thereafter. Dugan's named in the suit as well, and his attorney's already been served. The same attorney for his federal lawsuit. It's the same case. Dugan refused to recuse, and Manin Sala didn't require him to, claiming, well, it's a different case. No, you stupid fuck. It was just moved from one court to another, but it's the exact same case that he was sued because of. For fraud upon the court, 5th and 6th Amendment violations, 14th Amendment violations, 1st Amendment violations, conspiracy, violating his oath of office and his code of conduct, and other things. And they can look up the federal suit. All they got to do is check the federal fucking courts, and they'll see it. So, yeah. As of now, the trespass case is suspended till March, but as there's going to be a new judge, I'm going to file... tomorrow will be filed a request for a show cause hearing for the eval. And when the new judge comes in, I'm going to request that we proceed with the case in short order, since it's already been over a year and a half on a simple criminal trespass, when no other simple criminal trespass in the entire history of Jefferson County has taken this long to complete. And we're not even close to setting a trial date yet for this, let alone actually concluding all of this. 6th Amendment, anyone? Fair and speedy trial? Whenever you got fraud and 18 months for a simple criminal trespass, ain't nothing fair or speedy about that. So, yeah, that's where things stand. There's really, other than the recent court hearings with Manin Sala, there's really no updates to give. It was just yesterday or the day before that I got the email that they finally appointed a judge 2 months later to the protective order case. So, I mean, there's literally been nothing to tell. So sometimes things take a bit of time in law, especially lawsuits. Those can take years. If we make it past motion to dismiss and it gets to go to discovery, if they don't settle, which I have no inclination to do, I've offered to repeatedly and they've refused. But if it doesn't settle and it actually goes to trial, it could be another 2-3 years or longer before it ever goes to trial. And then however long the trial is, wouldn't be super long or anything, but then it'd still be a couple months or anything before anything's fully fucking resolved. And then you'd have appeals, which would take even more time. So 7-10 years. So I mean, these things don't go quick. They're actually pretty long and drawn out. So they're not for the faint at heart. But that's the nature of the beast. Civil doesn't have the same requirements as criminal, so there is no fair and speedy trial guaranteeing the Constitution for civil issues. That's for criminal issues. So, such as a criminal trespass. But yeah, that's all I got. That's all the update there is currently. If there's a school board meeting before the court hearing for the protective order, I do intend to go. Seeing as there's no temporary order or anything in place right now because I've never been served with one. The last one expired at the court hearing. Nothing was ever entered from there because I've never received anything or, never got an email from the courts, and I get emails about everything entered in the courts, and since there was never anything entered, temporaries don't just magically extend for an indefinite period of time. That temporary expired. As such, I'll be going to the next board meeting to address the board only. So, I'll post that video then. Until then, peace.